Good morning, everyone. Thanks for joining us this morning. And we would obviously normally be at the State Theater, but we are Zooming this year. Thank Alondra for spearheading our efforts this morning. She always does a great job getting us all together. Before we get started with Gov, Ivo and Kristen are joining us from American Home Shield. Ivo is the regional team leader. He's going to share a few thoughts with us. And I think we've had a strategic relationship with American Home Shield since like the horse and buggy days. So we appreciate them very much. Following Ivo, our notorious General Counsel Jim Oliveira is going to share a few thoughts and introduce Gov. And when Gov is speaking, there's a Q&A portion on the Zoom. If you have questions, enter them there. He'll be monitoring them. So Ivo, take it away.
Good morning, everybody. A little different from what we've experienced in the past, and I'm very happy to be here with you today. I hope everybody's staying healthy and safe as we continue through this really unprecedented time. I just wanted to share some of the things that we're doing at American Home Shield and kind of introduce some new things to you. And I've been trying to get this PowerPoint to work. Well, there we go. So let's see if I get this to work now. So as many of you know, as Ben said, we have a history that goes back to 1971. So we're almost 49-year history with PMZ. And that's something that we take very near and dear to our heart, especially me and those of you that have known me for the last 5 years. I always love sharing this slide with you because this is back from the 1973 Modesto B that Ty shared with us, and it shows the relationship that we've had with PMZ to all these years, and why we take you and your clients and our times together so seriously. And I've been very honored to be a part of it for the last 5 years. So as many of you know, about 2 years ago, a year and a half ago, American Home Shield was acquired by Front Door. And we've been slowly transitioning and making a lot of great changes and strides to provide the ultimate in the home warranty experience. And I'm going to share some things with you today. And there's going to be a lot of great things coming down the pike in 2020. Because even though we're in these very unprecedented times, we're moving forward to provide something that's never been provided before. In 1971, American Home Shield founded the home warranty industry. We were the first company. And in 2020, we're going to bring some things to the market that we've never had before. Many of you in my presentations have heard about 65,000 technicians that are registered and vetted by American Home Shield. That's really been an insignificant number until the last 2 months, because these 65,000 technicians that we work very closely with, and we have a team of over 200 contractor relation managers, are every day make sure that we go out and we service every one of our customers. And again, under unprecedented times, to make sure that every service call, every claim is handled. In our world, in American Home Shield, there is no such thing as essential or unessential services. There is no such thing as essential or unessential clients. Every single service that we trade that we service, and every single technician is essential. And this is why we are now become the largest home warranty in the company in the nation, with over 2 million customers, growing every year. And we're now included in over 400,000 real estate transactions per year. So yeah, we live in a very unprecedented world today called COVID-19, but we as a company have not used this time to do anything but move forward and become stronger and become greater. And I want to share some things with you that I'm incredibly proud of, and I'm incredibly proud to be part of this company, Front Door and American Home Shield. In less than 8 days, we transitioned 3,000 employees from offices to a home base. And we made sure that we kept business as usual. We tried not to skip a beat. And when you think about it, that 3,000 employees went from coming to an office every day to being able to handle over 300,000 claims. In those 8 days, we found out that in order for those 3,000 employees to service our customers, we needed a new phone system. So Front Door invested millions of dollars into getting a new phone system. So every one of our home-based agents, and operators and customer service give the same experience that we were able to give when we're all in an office. One thing I'm incredibly proud of is that our company has not had a single layoff during this time, and we've continued to hire and train new associates, and we're gearing up for what we call the warranty summer, where we get about 80% of our claims between April and October. So we continue to grow, we continue to meet all of the needs, and we continue to support all of our employees and make sure that we continue to add to our staff. In March and April, we handled over 600,000 service requests. We broke all records because as we all live at home, more and more of us are using our homes in a way that they've never been used before. So those 65,000 technicians are what are allowing us to basically handle business as usual. The amount of time that it takes for a technician to go out today is not that much different than it was 3 or 4 months ago. And again, I'm not aware of any service that is being skipped or lacked or in any way. We do have some challenges, absolutely. A lot of them have to do with distributors of parts who have shut down or cut down, but we are every day sending parts, paying parts to be shipped overnight to make sure that we service our clients in a timely manner. We set up a COVID-19 helpline, and that line is specifically for customers that have the COVID and who therefore need special care and special circumstances in servicing of their homes. We have now handled over 10,000 claims in the past 2 months of homeowners who are exposed to COVID, and we made sure that our technicians are protected and as well as the homeowner is protected when we service their home. And during this time, we donated over $750,000 to Feeding America to make sure that those that have been affected by job loss and other unfortunate circumstances by COVID-19 can continue to get some support and food on the table. In the last month, American Home Shield wanted to make sure that, again, not skip a beat when it comes to claims. We donated over 200,000 masks to our contractors. And we're now securing more and booties and gloves to make sure that every time a contractor walks into an American Home Shield customer's home, they are protected and the homeowner's protected. Because at the end of the day, the most important thing is safety comes first. So one of the biggest changes for 2020 is I recently was promoted to regional team leader for Northern California, and I'm very proud for that. And we now have a team servicing PMZ. So you're not losing just me, but you're actually gaining a whole team that includes me. And part of that team is Kristen Aguilar, who's been our account executive in Merced and Fresno County. She and I are now partnering together. So I'm going to be a working manager to make sure that we continue to give you the customer service and to raise the bar. We also have Stacy Burke, who's an inside sales manager. Stacy's going to help us to make sure that, again, that we can provide you and your customers with inside support. All of this information is going to be provided to you. So you guys are going to have this at your fingertips should you need to contact any of us. And then finally, Tammy Bagby. Tammy is our field sales coordinator. This is almost like our own personal customer service format. She makes sure that all the claims that PMZ customers come in are handled in a timely manner, that they're monitored and that they're expedited. So you now have a team of 5 that is able to raise the bar and provide a level of customer service that no other home warranty company can. And like I said, I'm not going anywhere. I gave a promise to Mike Zagaris when I came on board 5 years ago. I intend to keep that promise, and I'm very proud to have Kristen, Stacy, and Tammy all part of one team for PMZ. And I'd like to introduce Kristen. Some of you have already met her. So Kristen, you're on.
Yes, hi, good morning, everyone. I just wanted to introduce myself real quick. So I cover just about all the Central Valley. So I am from Fresno County. I'm now all the way up to San Joaquin. Born and raised in the Central Valley, so I'm a true Valley girl. So I look forward to getting to know you all. Please know I'm here to support you, support your business. So reach out to me directly. I know I've been around a little bit over the last few years. I know I've always attended this legal seminar, which is super fun. So I look forward to seeing you at future events. Hopefully 2020 ends a lot better than it started so that I can see you guys, but never hesitate to reach out to me. Of course, Evo as well, but I really would like to, get to know you guys and your support system. So thank you.
Yeah, Kristen's one of our senior account managers. She excels. She has a great following in Merced and Fresno, and I know she's going to bring a lot to us at PMZ. And also, since my role has changed to make sure that we continue with providing you much greater customer service with the team of 5. So, people always ask what sets you apart from the competition. Last year, we spent $573 million servicing our customers. That is more than most of our competition combined. We're now on a pace to, because of COVID, because of the number of claims, to crush that number and raise it significantly. So we put our money where our mouth is every single day, and we want you and your clients to know we continue to do everything we got to have your back. So this is a perfect time, again, with all the contractors that we have on board. They've all been trained to follow the CDC guidelines when they enter a home. It takes a lot of the worry out of who to hire when you have to have somebody come into your home. So this is the perfect time to continue having that home warranty, adding it to your every transaction that you have. And again, I want to thank everybody for all your support for me and American Home Shield. I want to welcome you to our new team, and always remember, keep calm and call Evo and Kristen. I wasn't able to add Kristen on there, but we are always there for you. So thank you very much. And this guy is hoping and praying that very soon he'll be able to don that red suit and see you guys once again. So keep on that good list. Thanks, Ben. Thank you, everybody. Have a great day. Stay healthy, and hope to see you all soon.
Thanks, Evo and Kristen. So I'm going to get to Gov really quickly. I just want to say very briefly, everyone hear me? Yeah. So, everyone knows Gov is with the California Association of Realtors, and I just want to throw out there that in my opinion, CAR has been absolutely indispensable in recent months, and they've been indispensable in at least 2 ways. One, on a lobbying front, they've helped ensure that our industry has been able to keep working by making sure that our state government, and they also lobbied to the federal government, considered real estate and real estate agents to be part of an essential industry. So huge props to CAR for that. And now that Uber and Lyft are officially in lawsuits with the state of California under AB 5, I think we also need to give credit to CAR to ensuring that tree hasn't changed, that AB 5 hasn't affected us, and that everyone on this Zoom has been able to maintain their autonomy as an agent. And I think CAR deserves credit for that too. So that was on the first. Second front is CAR has done a great job in educating and informing us during these times. They've committed a lot of resources to helping us understand our transactions, producing new forms, that sort of thing. And they've even gone so far as to provide assistance with helping agents understand the CARES Act. And I know a lot of you have looked to those resources in recent weeks via their website that I've been recommending for weeks now, which is CAR COVID Updates. And I don't remember if it's .com or .org, but it's one of the two. And then CAR keeps us updated keeps us informed and educated is by providing us access to Gov Hutchinson, whose time I won't use anymore. So everyone, here's Gov. Thank you, Gov.
All right, good to be here. Sorry, I'm not there in person. I always look forward to my one day a year where I feel like I'm in show business at the theater there, but maybe next year. I hope next year we'll be able to do this. I just want to update you on what's going on. As Jim said, we're in a different world right now. It's not going to be like this forever, thank goodness. But we got to deal with what we got to deal with right now in the COVID-19 era in real estate. As Jim said, about 2 months ago, believe it or not, it's only been 2 months since this all started. You remember on the very first day when it started, real estate was not considered essential, but we got that fixed in about 5 days. So ever since then, real estate is essential so you can work. But of course, that doesn't mean it's business as usual. In other words, the governor's order basically incorporated in these federal guidelines and these CDC guidelines, making it clear that there's certain things you can't do right now. In other words, some of the things you have to be careful about. You can't do open houses or broker caravans or anything like that. Showing properties, should be one agent, two buyers, everybody standing 6 feet apart, wearing gloves and a mask. In other words, we took the governor's order as well as the industry consensus of how to do things and created these best practices. And not only did we create these best practices, we created a couple of forms that help you to put these best practices into place. And I'll talk about these forms in a second, the PEAD form and the coronavirus addendum. Okay, so then things got complicated, and various counties out there like San Joaquin County, Stanislaus County, a lot of counties come up with their own rules. And some of those rules were stricter than the best practices. But of course, if the county comes up with a rule, that's the law, you have to follow it. And even if it's stricter than the basic state rule, okay? So, but as you also know, Jim's been keeping you informed about, how San Joaquin and Stanislaus, for example, have pretty much modified their rules recently. So they're pretty much consistent with the rest of the state as to what you can do and can't do. I think one thing that was different is you're only supposed to show properties when the occupant isn't there at the time, right? Which is probably a good thing anyway. And I think San Joaquin, Stanislaus says that you should only show properties to serious buyers who've already pre-qualified, or you want to show properties to anyway. And the point is, counties have their rules, state has their rules. They become pretty consistent, so you pretty much knew what you were doing. Then something happened last Thursday. Finally, the State Department of Public Health and the DRE decided to issue their own state rules, okay? In other words, previously we had the governor's general directive that incorporated federal guidance and CDC guidance, but there was no official state rules on how to do real estate other than your essential. Well, now the state has finally gotten into the act and they've come up with this real estate guidance. They're supposed to guide all realtors in California. Now, the good news is, you know what they did? They basically incorporated our best practices that you've already been following. Keeping in mind, though, that anything that's stricter in the county rules or city rules would supersede anything that the state does. But as I said, my impression, standardly following the state. So you're pretty much okay to do what the state says. So in other words, so these new guidance that came from the state last Thursday night has these rules. So these are now rules. So our best practices all this time was sort of a recommendation. Part of it was sort of required, wasn't, but now it's actually required. So in other words, our best practices are now the law. Now there are a couple things we're going to have to change in our best practices to make them consistent with this new thing. One of the things is that when you show a property, the occupant shouldn't be there when you show it. But you guys are used to that because that's already been the Stanislaus County and San Joaquin County anyway. So that's nothing new for you. You know what else? Little things like when you go into a house, you're probably already doing this. Make sure all the doors are open. So when people are walking through the house, they don't have to open any doors. That makes sense. And it also says you should wipe down not just surfaces, but you should also wipe down banisters and hand railings. I think you're okay with that too. None of that's a big deal. Couple of new things are, though, that one of the things it says, okay, every company has to adopt a COVID-19 prevention plan, how you're going to do your business in a safe manner. Well, guess what? Our best practices qualify as the prevention plan you're supposed to have in place. So as long as your company adopts our best practices as official, then you're good. Second thing, these new rules say, well, everyone who enters a property has to agree to follow certain rules. Well, guess what? That's the PED form, isn't it? So up until now, we've been able to tell you the PED form is good, recommended. Maybe it's company policy, but it's not actually required by law. Not necessarily the PED form itself, but the equivalent to the PED form. So in other words, you might as well use the PED form since it's already there, right? And remember, that's the form that every buyer or agent or anyone who enters the property, they sign that and give it to the listing agent, basically promising they're going to follow the rules, not touch anything, wear the gloves, wear the mask. And they're also declaring on that form that they are not, as they know, they have not been in contact with someone who's sick in the last 14 days and they're not exhibiting any symptoms. So from that being a good idea and a nice form, that's now a required form or some equivalent form to that effect. And remember, the seller should also sign that form and the listing agent should also sign a form basically saying, when the seller and listing agent sign it, they're saying, I'm not sick, I'm allowing this showing, and I promise to clean, wipe down the property, clean the property after each showing. When the buyer, the buyer's agent, or the inspector, the appraiser, when anyone on the buyer side signs, they're saying that I'm not sick, no contact with someone sick, no symptoms, and I promise I'm going to follow the rules. Now, remember, the buyer needs to sign a new one of these every day. So if someone's coming into my house, I want to see a PEAD form dated today. Why not date it? What's wrong with the one dated yesterday? Well, their health situation may have changed since yesterday, right? So you're supposed to actually have a fresh one dated today and give it to the listing agent. Does the listing agent have to give one to the buyer's agent? You don't really have to. Listing agent and seller, you can just sign one. And then you don't have to give it to the buyer's agent. But if the buyer's agent says, can I see your PED form? I would show it to them. And if they say, can I have a copy from my file? I would give it to them. Why not? But it's just that the guidelines don't actually say you have to. But on the buyer's side, you really have to give them listing agent a copy. Okay. So anyway, but there's and there's one more thing. Listen to this. You're supposed to this effective 3 days or effective last Thursday, or you're supposed to post like on the front door, next to the front door of the house you're showing, a copy of the PED form, because the new guidance says not only do you have to follow the rules, you have the buyers sign the contract saying they're following the rules. You must post the rules on the property during the showing so that when the buyer comes there, they can see it. To me, that doesn't make sense. If they've already signed the form, why do they need to see it posted on the door? But I don't make these rules. This is the government making these rules. And we got to deal with it right now, okay? But there's one thing in these new rules we don't like. When I say we, I mean CAR, and I think realtors in general, because they put these very strict, onerous cleaning requirements. They say the house must be thoroughly cleaned and disinfected after each showing. And it also says that everyone who enters the property should wash their hands once they get there. Well, isn't that kind of dumb? Don't you want people to wash their hands before they get to the property and wear the gloves when they're on the property, and then don't touch anything on the property? And then if no one's going to touch anything on the property, why does the property have to be thoroughly cleaned and disinfected? I mean, The guidance says you're supposed to clean the toilet and the bathroom. Why would you do that if no one's going to use it? The point is this: CAR is pushing back against the government to try to get this guidance changed so it doesn't have these onerous. We just started this process yesterday, Monday, so we haven't really heard back from the government yet, or maybe today we will. So if you're going to ask me point blank, what do I have to do today, Tuesday, I'm going to say, well, the new guidance is to do everything the new guidance says. And I think everything I've said you're fine with because you've already been doing it, with the exception of the thoroughly cleaning after each showing, whatever that means, by the way, and also the hand washing in the house itself. So I don't know. I don't know what to tell you. I'm a lawyer. I can't tell you to violate the law, and I'm not telling you that, but that's what the guidance says as of today. By the way, no open houses. People say, hey, it says in the guidance I can do open houses. No, it says in the guidance, no open houses, semicolon, but you can have, or digital sign in. So realtors read that to say, oh, great, I can do an open house as long as they sign up to enter digitally. But that's not what the rules say. I mean, anytime any buying party enters the property, that's a showing. And you can have one buyer's party at a time in the property. And then according to these new guidance, you got to thoroughly clean each time. So I guess theoretically, to me, that's not an open house. An open house isn't appointments. To me, an open house is anybody can come. I mean, I guess theoretically, you could set up a situation on a Saturday or something where you can have buyer party after buyer party coming into the property one at a time, but it's got to be by appointment, and you have to thoroughly clean after each one. And the next question was, who has to do the cleaning, right? Well, originally it was very clear it was the seller. Now, if you read these new guidance, it's like the seller and the listing agent also have responsibility. So we're going to try to get that changed too. And like I said, we don't think there should have to be a thorough cleaning anyway. Doesn't it make sense that if people are washing anything, you just wipe down the surfaces that might have been touched? Anyway, so that's where we are right now. We'll probably have, in a couple days or so, we'll have an answer from the government. Hopefully it'll be positive. And then we're going to update our best practices to incorporate the minor changes that I've talked about today. But you're still going to, that's going to be your official company policy of your official prevention plan. And then you're still going to use the PED form, and then you're actually going to post the PED form on the front door, unless we can get that changed too. So sorry that I happen to be here in this little interim period, the way it is. So you got to deal with it the way it is. Okay. Maria's asking, yeah, who's responsible to do the cleaning? Doesn't it fall to the owner? Like I said, up until now, it was the owner, but now this new guidance tries to put it on the listing agent too. So hopefully we're going to get that changed. What happens if you have an agent showing your property that is not following the protocols? Well, that's sort of up to you on the listing side. You can certainly say you can't come in here unless you're wearing gloves or a mask, because that's what the rules say, and you're supposed to follow the rules. And you're supposed to give me a PED form that says you're not going to follow the rules. But what if they come in anyway? It's up to the seller and the listing agent. If you want to let them in without the mask, you let them in. And you shouldn't. It's not safe, but I mean, you know what I mean? It's ultimately going to be up to the listing agent and the seller. Do you have to get one from each inspector during home inspections? Yes. And that's really clear on the new guidance as well. Any inspector enters the property, yes, you still have to, they should still be following the safe practices and signing a PED form. Sherry, what about vacant homes? Yes, this applies to vacant homes. I mean, I don't know how if someone goes into a vacant home, I don't know what type of to do. That doesn't really make sense, does it? But nevertheless, they're still supposed to sign that PEAD form and wear the gloves and wear the mask and don't touch anything. Robin, what if it's a vacant property and the seller's out of state? I know what you're asking me. who's going to wipe down the property if the seller's not there? Well, I think it's going to be you is what it's going to be. And for vacant, which means you can't really have a lockbox on the property that allows anybody to come onto the property anytime they want, right? Because then how are you going to make sure that they're providing the PED form, and how are you going to make sure that the property is being wiped down, at least any surfaces like the doorknob, at least that was being touched. And as I said, as of today, unfortunately, the guidance says a thorough cleaning and disinfecting, whatever that means. Anyway, so that's the way we are right now. Okay, a couple more things. Let me talk about a couple more forms. You're probably familiar already with this, but so I've talked about the AD form, and it's now required, and it should be posted as well, and everyone's going to sign it. You got that. Another form, I don't know if it's company policy to use this or not, but just make sure you're aware of it, is the coronavirus listing addendum, the RLA-CAA, that stands for Residential Listing Agreement Coronavirus Addendum. I think it's a good form. If I was a listing agent, I would want my seller to sign it as an addendum, because on this form, the seller promises that they're going to follow the best practices, and they also promise that they're going to indemnify me, the listing agent, if they screw up or somebody else screws up and there's a problem and there's a lawsuit because someone didn't follow the rules. I'm not going to get, I don't even have to turn over this law because the seller has to indemnify me for any issues, because I did my job by telling everyone the rules and making sure they follow the rules. And if they follow the rules, they're acting against my advice, and the brokers get indemnified. It also says on the PED form that the buyer, anyone entering the property, is assuming any risk. They understand this is not a risk-free situation, and they understand if they don't follow the rules, they're acting against the broker's advice. So these two forms really protect you in a legal way, right? Sudesh, do we need any certified cleaner? Who knows? I mean, we're trying to get that clarified. I don't think you need a cleaning company, but you will find out by the end of the week what the answer is as to what are the specific rules on cleaning between showings. Anna, is it okay to show vacant homes without a mask? No, the same rules apply on vacant properties. Everyone should be wearing the mask and the gloves, even on vacant. Leah, if the buyers are supposed to wash their hands, the seller providing soap and paper towels. If they have gloves on, why would they wash hands? Exactly, Leah. That's why we don't like the brand new guidance that came out, which is why we're trying to get it changed so it makes more common sense, right? I mean, why on earth, if they have gloves on, would you want them to wash their hands inside the property before they get there? I mean, once they get there. But you're right, if that's the rule, then the seller's gonna have to provide the soap and the paper towels. That's why we're trying to get it changed, okay? Letitia, if it's posted on the door, how do I get a copy? Well, you can make copies of the PED form. I think the one that's posted on the door can just be a blank PED form, but then the buyer and the buyer's agent still need to sign one and give it to the listing agent. And the listing agent's supposed to sign one also, and there's supposed to be a blank one posted on the door. Maybe this will get tweaked this week also. Everything I'm saying will be in the updated best practices that will be out as soon as we have answers to some of these questions, okay? All right, a couple more things. So those are the big things, the rules on doing business. I didn't even ask before I started talking, and I don't want you guys to tell me, but another thing that happened on Thursday is they came out with rules to follow if you want to open your real estate office. Now, I know some companies have already been opening their office, and up until now, I've been saying, you know, if you're going to open your office, you really shouldn't allow the public in, or just have someone go in there to you know, check the computers and turn off the lights and pick up the mail or whatever. But now, if the government says, yes, real estate offices can open up, but if you want to open up and allow the public in, you have to follow certain rules. There's certain practices you have to set up in your office. So you have to train the agents and orientate your office so there's social distancing and make sure people don't gather in the break room, or and if anyone gets sick, there's a protocol you have to follow, and you may have to put up barriers. And if you have a receptionist, maybe you're supposed to have the receptionist behind a plexiglass window so people can't cough on their, I mean, you have to do stuff. If you want to know exactly what you have to do, we created a template and we emailed it, I believe, every single broker in California. So you should have gotten it. And if you have questions on it, we can talk to you about it. But the point is, yes, you can open your office and let the public in, but only if you follow these rules. Okay. So two things happened last week. Number one, the state finally has their own guidance for doing transactions and showing properties, which basically mirrored the best practices CAR already was recommending, and they added a couple things and a couple of the things we don't like, so we're trying to get them changed. Number two, what steps you have to follow if you want to open your real estate. Okay, and we sent that to everybody. That's not going to change either. We're trying to get the showings rules changed, but the rules for opening offices, that's not going to change. So you have to deal with that to the extent you want to open up your offices. Okay. All right. Next thing I want to talk about, things you probably already know, maybe. So new forms, right? There's 6 new forms. I've talked about the PED form, which you're all going to use. And I talked about the coronavirus addendum form, which I recommend you use as a listing agent. 2 more forms you don't have to use, but I recommend. We have one called the coronavirus addendum, the CVA form, that deals with the following issue. We're in a new world right now, temporarily, where things are, you heard from Home Warranty, they're doing business. I mean, appraisers, everyone's doing business, but sometimes they can't do it as fast as they used to. Sometimes loans take longer, appraisers take longer, inspections take longer. So sometimes there are delays in escrow, or sometimes the buyer gets sick, or they get sick in escrow and they need a delay or a cancel, or maybe the buyer loses their job in the middle of escrow or something like that. So the question is, if something like that happens in the middle of escrow, and I'm the buyer, let's say, and the loan's taken long, I need more time to extend the contingency removal date or extend the closing date or something like that. So this form, the idea of this form is, if the buyer and seller incorporate this form into their purchase contract, the CVA, the coronavirus addendum, you know what it says on this form? It says buyer and seller agree that if something comes up in escrow that causes a delay of some kind, both the buyer and the seller were agreeing up front to an automatic extension. It says in the form 30 days. So you can change that. But let's say I'm the buyer and you're the seller, and we sign this coronavirus addendum to the purchase contract. We both agree that if there's any COVID-19 related problem, there's an automatic 30-day extension. So now we get an escrow and I'm the buyer. Sure enough, the lender's delayed. Sure enough, the appraiser's delayed. Or maybe my relative got sick. Someone has to take time to take care of them or something like that. So I need an extension. But I don't have to ask for an extension because you and I already agreed up front that if something happens COVID-19 related, there's an automatic extension. So as soon as the problem happens, excuse me, I'm going to send you this other form called the NUCC, the Notice of Unforeseen Coronavirus Circumstance. And this is the form where I tell you, yep, I have a lender problem, an appraiser problem, a health problem, a job problem. And when you receive this form as a seller, that kicks in the automatic extension that we agreed to on the coronavirus addendum if we used it. Now, what about this situation? What if there's a problem, the buyer the loan process is delayed. We agree to the form. I give you the notice. So it's extended another 30 days. 30 days later, I still can't close. The lender's still backed up. Now what happens? Well, we can either negotiate a new extension, or it says on the CVA form, if that happens, either the buyer or seller can just cancel. So now I know what you're asking. Well, if that happens and the buyer or the seller cancels, does the buyer get to keep their deposit, or does the seller keep their deposit? Okay. All right. Interesting question. Well, it depends on how you fill out the form, because there's a box on the form that says if either side wants to cancel, either the deposit goes back to the buyer if you don't check the box. If you check the box, the seller keeps the deposit. I know what you're thinking. The buyer's only going to want that form if it says they get their deposit back, and the seller's only going to want the form if it says they get the buyer's deposit. So what if they can't agree? Well, guess what? If they cannot agree, you know what that means? That means they can't agree to use this form, and it's not part of your escrow, which leads to the next question. What if you don't use this form? You're in escrow. The buyer removes their contingencies, and then they get laid off from their job because of COVID-19. Do they lose their deposit, or do they keep their deposit if you didn't use this form? What's a judge going to say? Well, there's a law in California, Civil Code 1511. Some people refer to it as the Act of God law or the force majeure law, that says if anyone's in a contract and because of some irresistible superhuman cause, they're unable to perform their contract. In other words, there's an earthquake, there's a fire, there's a World War III happens. If something like that happens, you can get out of the. So the question is this pandemic going to be considered the type of event that allows people to just walk away from their contracts? And the answer is we don't know yet. And it might depend on the circumstance. I bet if someone actually gets sick with COVID-19 or loses their job, they can probably get out of it. But if something else happens, maybe they're just worried about losing their job or something like that, or they lost money in the stock market, they're uncomfortable going through with the deal. The judge may say, well, okay, but you could still go through with the deal, so you still got to go through with the deal. Say, which is one reason you might want to consider using that addendum, because then the buyer and seller decide what's going to happen as opposed to some judge. But anyway, that's where we are with that. Okay. Next topic. Let me see a couple questions. Let's see here. And Jim told me someone's going to ask the question about, can the agent put to be determined in the address rather than a specific address if showing more than one property on the PEAD? So I'm going to let Jim decide whatever you guys are going to handle that, because I never like to argue with the counsel at the companies that I'm talking to. So do whatever Jim says.
My take on that, Gov, is if you represent the buyer, the representations coming from the buyer aren't attached to any particular property. Representations that the buyer isn't sick, that he's going to maintain social distancing, that sort of thing. So that address per se. So in my opinion, using to be determined at the top is sufficient. But what I've been telling everyone is that if the seller requires that you use their specific, whatever the seller's agent wants you to do. So that's been my take on it.
I think that's a good answer.
And
I'll go
you're
along.
allowed to disagree with me anytime too.
I mean, it's just, the only thing I've something about it, which is probably unforeseen, is that someone's going to claim, oh, you never gave me a form for this. You never gave me the PAD form because it doesn't have an address on it. I think it's extremely unlikely.
The point you made about the date earlier is more important in my view.
Yeah, I agree with that. So we definitely 100% agree that it's got to be a new one each, okay? But I will go along with what Jim said as in general, okay? Anna's asked me, is a certain age that cannot be allowed in property insurance or showing homes? I mean, that's a good question, right? Because Anyone who goes onto the property is supposed to sign the PEAD form. But can a minor child really sign that form? Do they really have the ability to consent to this? Because they're really only a minor. That's why I think in a perfect world, you try not to have the children come into the property. Because how do you deal with the whole PEAD issue, right? So, and that's a hard one. So I'm a single mom, this is my kid, I got nowhere else to take my kid, so, you know, because there's only supposed to be 2 people anyway. So if it's parents and a kid, that's already over 2, right? But yeah, okay, single parent and a minor child. I think in a perfect world, the kid stays outside and someone watches the kid. Because like I said, there's the issue with the PEAD of a minor actually agreeing to that. So I'll do it. Vanessa, yes, you can put more than one address on a PEAD form. Q&As. So the showing agent has to perform a thorough cleaning after every single person. That's what the current guidance that came out Thursday. Agent, it's the seller side who has to do the cleaning, the seller or the listing agent, not the showing agent, unless showing agent, you mean listing agent. We're going to try to get this changed. Can you attach the PEAD form to the listing? Yes, you can, sir. Should I always have all parties sign the PEAD form if I represent the buyer? Well, not everyone has to sign this. That's a good question too, right? Let's say, ideally in a perfect world, I think everyone signs their own PEAD form. Buyer signs one, buyer's agent signs one. You each give a copy to the listing agent signs it acknowledging receipt. If you want it, they give you back a copy with receipt. If you don't care, you don't care. But there is room for more than one person to sign, right? So I guess there's agent, neither one of them is sick, right? They have the same health situation. They could theoretically both sign the same one and give that one to the listing agent who signs it. Policy, follow your company policy, but there is room for additional people to sign. You know what I mean? Okay, anyway, let me keep going. Next thing I want to talk about real quick is rentals, because this is sometimes you're showing properties with a tenant in it, or you actually, some of you guys might be landlords. Some of you guys, I don't know if you do property management or not, but some of you may have your own rental properties. There are some things that are happening right now. Number one, we got this eviction moratorium in California, which says if a tenant can't pay their rent because of a loss of income due to COVID-19, you can't evict them until June 1st. But you can still evict them on June 1st legally. And you can even evict them before then, unless they can prove to you that the reason they didn't pay their rent is really because they lost income based on COVID-19. So we got 2 forms for this. These are the last 2 forms I'm going to talk about. There's a form called the NTAP, Notice to Tenant Regarding Ability to Pay Rent. Let's say I'm a landlord and I got a tenant, they didn't pay their rent on May 1st. I send them this form and I says, hey tenant, I noticed you pay the rent. Well, I hope the reason you didn't pay the rent was because you lost income regarding COVID-19, and you have to prove to me that that's the reason. Otherwise I can evict you. It basically says that. So then the last form, the form that the tenant uses to respond to you, it's called the RPD, the rent payment delay. And this is where the tenant sends it back to me, the landlord, says, yep, I lost my job. Here's the note from my boss laying me off, or I got sick, or my kid or my mom got sick and I have to take care of her, blah, blah, blah. So if they send me that back, okay, I can't evict them till June 1st. Well, can I evict them on June 1st if they don't pay up the back rent? Normally I say yes, but then the next question we have to ask is, me, the landlord, I have to think about what type of loan do I have on my property. If I have a federally related loan, FHA, VA, or just a conforming loan, a standard Fannie or Freddie loan that's secured by my property as a landlord, there's a nationwide eviction moratorium on those types of properties till July 5th. So it's not that I have to wait till June 1st to evict. I have to wait till July to evict. Now, the tenant still owes me all the rent. It's not like they don't owe me the money. It's just I can't evict them until July 25th. Whereas if it's not a federally related loan property, or if I own it free and clear, then I can do it June 1st. But there's one more problem. The courts of California are closed for unlawful detainers till August 1st. So that's the only date you really got to remember. I can't evict anyone until August 1st. No matter what, commercial, residential, COVID-19 related, not COVID, all of that is on hold August. Well, let's say I got a tenant today and won't let me show the property. Well, normally I could evict them for not letting you show the property, but not right now. Does that mean they can prevent me from showing the property if they live there? Yes. But that doesn't mean I can't say to the tenant, you know something, allow me to show the property, that may blow this deal. And if that blows the deal, that costs me money, that costs the seller money, that costs the buyer money. And we're going to hold you financially responsible for all that money. We're going to do for damages. Maybe that's enough leverage to get them to work with you. Or what if you're selling it and already there and you want the tenant out because the buyers wants to live there? Can I give that tenant a 60-day notice? Well, sure you can if it's a single family home, or if it's a home that's it's a rental property that's 15 years old. It's newer than 15 years old. It's built in the last 15 years. So you're not under this new just cause eviction thing. And even if it was an apartment building that was older than 15 years, you could still evict them if the buyer wanted to actually move in or a member of their family. So the point is, of course, you can give them a 60-day notice, but then 60 days go by and they don't leave. Now what do I do? Well, 60 days from now is going to be in July, right? So you'd still have to wait till August 1st before you could actually evict them. On the other hand, you could threaten to sue them or actually sue them for damages for them not leaving when they're supposed to, right? So it's not like tenants can do whatever they want. It's just that you can't physically evict them, and they do owe the money. Unless you live in a city like Los Angeles, where I live, which says the tenant has 12 months to pay you back the back we didn't pay during the COVID-19. So you would know better than me if Modesto or Stockton or any other cities where you live has any enhanced tenant protections. LA also has a rent freeze right now, that whether you're under rent control or not, you can't increase anybody's rent. If you want to know what the rule is in Modesto or Stockton or anywhere, we have a chart on our website. You just go to car.org and you type in the search eviction moratorium chart, and it'll show you the rules for any city that you might be relevant to. Or you can just call the legal hotline or help you with that one too, okay? Next thing to talk about real quick, we have something called mortgage forbearance right now. What does that mean? Well, actually, there are two things going on. There's a foreclosure moratorium in California until June 23rd. So if you're behind on your mortgage, the lender cannot evict you until June 23rd. But that's only if the reason you're not paying your mortgage is because you have a hardship related to COVID-19. But okay, so let's say that's legit. And then what happens on June 24th? Can they just foreclose on me now if I don't make up all the back mortgage payments? Well, now it depends on what type of loan you have. If it's a federally related loan that is being secured by your residential property, Fannie, Freddie, or FHA or VA loan, if it's one of those loans, you're entitled actually to foreclosure forbearance. You know what that means? You're entitled to, not only can they not foreclose on you, you're entitled to defer your mortgage payment. Well, how long can I defer it to? Well, you got to work with the lender, but they have to work with you. They cannot demand a lump sum. They basically have to give you until basically a 12-month, the end of 12 months or even longer if they want to allow you to make up the back payments. So just like with the rent, it's not like you don't owe this money. You have to pay this money back, but depending on what type of loan it is, that may affect how long you have to pay it back. Whereas if it's a direct loan to, you know, Wells Fargo or something like that, it's not a Fannie or Freddie Mac loan, it's just a direct loan to your local lender or Wells Fargo or B of A or something. They don't have to give you a mortgage foreclosure forbearance. All they have to do is they can't foreclose on you until June 23rd. But on June 24th, they could start a foreclosure and demand all the money, all the back payments. You see what I'm saying? All right, so that's what's going on. So we got evictions, we got foreclosures, we got these rules on how to open an office, we got rules on how to show property, no open houses. I told you the forms. The PED form has just become a mandatory form. The best practices have just become mandatory. The other forms aren't mandatory, but they're good and helpful if you want to use them. By the way, speaking of forms, the purchase contract, you may have heard that the purchase contract was going to be significantly updated this year. That's been pushed back a whole nother year. So there are going to be no changes to the your purchase agreement until December 2021. So it's going to be the same form. Let me do a couple more questions. Maria, am I legally able to send a 24-hour notice for access to the tenant occupied property for showing? Yes, of course you can. But my point is, what if the tenant says, I don't care about this notice. I don't want people coming in the house. I'm scared they are sick. So I'm not allowing anyone in. They don't have the legal right to say that unless they themselves are sick, in which case you have the right to say it, but you're not going to be physically able to evict them for not following the rules, okay? Yes, Robin, you should, I already talked about that. Kenneth Russell, REO listings. Yeah, all this applies to REO listings, even though the REO listings usually think they don't have to obey any of these rules, but these are rules they have to follow. Mary Sanchez, the PED form should be signed by the seller before showing and then return after the buyer sign. The deal is this. Remember, the buyer signs the PED, gives it to the listing agent. You don't need the seller to sign it. All you need to do is give it to the listing agent. Now, you, the buyer or the buyer's agent, you may want to see the one the seller signed because you want to be sure that the seller has signed a form saying they're not sick and they're going to clean the property. But the seller doesn't have to sign the one that the buyer signed. The seller should sign their own. The buyer should sign their own. John Medeiros, yes, as of 3 days ago, the PED form should be posted somewhere on the door, near the door, so that everyone can see when they're coming into the property that the seller's going to follow the rules. Okay. What do you do if an appraiser refuses to sign it? Once again, that's up to the seller and the listing agent. I would say, appraiser, you have to follow these rules, sign the form. What if the appraiser says, well, I'm not signing? Are they also saying they're not going to wear the mask, or are they just saying they're not going to sign the form? Then you're going to say, well, yeah, what if they say, I'll wear the mask, but I won't sign the form? They say, why, are you sick or something? You're not telling me? He says, no, I'm not sick. I just don't want to sign the form. You know, it's up to the listing agent, the seller, what you're going to require and what you're not going to require. I mean, if you trust them that they're telling the truth, even though I don't know why they wouldn't want to sign the form. The form's required. It's easy to say don't do it, but it's ultimately going to be up to the listing agent, the seller, to let them in. Who is responsible for providing the masks and the question? Up until 3 days ago, whoever was entering the property was supposed to provide the mask and gloves. But isn't it a good idea as a listing agent to have a supply on hand anyway? Because what if a buyer shows up without them? Isn't it helpful if you you have a supply that you can give to the buyer or the buyer's agent. So I've always said it's probably a good idea, even though you don't have to. Guess what? The new guidance that just came out 3 days ago, yes, the seller side is supposed to make sure that you have them available to give to people if they show up. What if you don't have them? Well, then it's up to you if they show up without them. Remember, that's what I just said. Does the seller, Brad Young, does the seller have to sign a new PED every day? No. Does the tenant who occupies the property have to sign one? Yes. Do they have to sign one, new one every day? No. But if the occupant of the property, either the seller or the tenant, if something happens to them, let's say they get sick or something, or have contact with someone that's sick, obviously they have to disclose that as soon as it happens to anyone who starts coming into the property. So I'm saying you don't have to do a new one unless your health situation changes, okay? Jill, do I recommend the listing agent attach the PED form that has already been initialed to the listing on the MLS? I think that's a great idea. Do you need the buyer to sign a PED form? Property is a vacant lot. So it's not just vacant property, it's raw land. So there's no real property that they're entering, right? They're just walking onto land. You know, the rules don't address that at all. So your guess is as good as mine. I think if you're walking, and I don't know, if you're in LA, you're supposed to wear a mask when you're outside no matter what, right? So I don't know if you have a rule like that there. Technically, I don't think you're really entering a property if it's a vacant lot. So I don't think you necessarily need it. I think everyone should still stay 6 feet apart and wear a mask, but you're right. Diana Brink, recently 2 different lenders did not require appraisal as a condition. Good to know. Okay. Does the rental and eviction guideline include single family home rentals? Yes. Can owners still charge renters late fees on rent? Very good question. If the reason they didn't pay the rent is because of COVID-19, don't charge them a late fee. You can still evict them on August 1st, unless you live in LA or something, but don't charge them a late fee if that's the reason. Melanie, yes, for forbearance scams. All the criminals are out there trying to scam you now. Just be careful. If you get something that looks like it's from your bank, that says you got to do this or this if you want to get the forbearance. You know, it's always a general rule. Don't trust the emails. Talk to somebody at the institution to find out what's really going on. And a good question. What happens if a renter and landlord comes into an agreement to move out and the renter ends up not moving out? Knowing landlord cannot take them to court until August 1st, right? You're right. I mean, I don't know what to tell you. You know what some landlords have been telling me? Like, they say, how about this? I'm going to rent to a new tenant today, but how do I know they're just going to sign the lease, move in, and then not pay? Because they know I can't do anything till August 1st. So the question is, can I like 3 months rent in advance, non-refundable? Well, in California, you can collect advance rent, but you know what the problem is? It has to be a minimum of 6 months advance rent. So you can't collect 3 or 4 or 5 months advance rent. You can collect 6 or more. So that's something to think about, right? Okay, that's a possibility. What else is going on? We're almost done here. I might as well tell you a couple of things that have nothing to do with COVID-19. How do you like that? We still do regular forms. So a month from now, mid-June, there's going to be 2. So I told you about the 6 COVID-19 forms. 2 new forms are coming out that have nothing to do with COVID-19. They're coming out in mid-June. They're not a big deal. They're good forms. They're not mandatory forms. One is called the Property Visit and Open House Advisory, PVOH, Property Visit Open House Advisory. And this is a form that you would give to anybody, forget COVID-19, forget anyone who comes to any open house once we start doing open houses again, or any listing, any appointment, you give this form to the buyer. You know what it tells? Hey, buyer, this is a warning. Anytime you go in someone's house, you never know if the house might have hidden microphones and hidden cameras, or the house might have a bump in the carpet that you might trip over, or there might be a loose step in the backyard, or it might be a dangerous slippery whatever. You're giving this form to the buyer, and by signing it, the buyer is acknowledging that they gave you this and they promise they're going to take care of themselves and watch out for themselves and watch out for their kids, and they're assuming the risk, and they're basically not going to sue you if they trip and fall or if they find out they were recorded without their knowledge. Now, having said that, of course, if the seller or the listing agent is aware of any sort of dangerous thing on the property to be careful of, you're going to tell them. And the seller is supposed to disclose by putting up some sort of sign near the front door if the property does have hidden cameras or microphones. But some sellers don't do that, or some sellers don't disclose problems that they're aware of. And this protects you, the realtor, no matter what, if anything goes wrong, because the buyer's saying they're assuming the risk, okay? The second and final new form coming out in June is called the Square and Lot Size Advisory, FLS. Have you noticed that, of course, every single time you sell a house, the buyer wants to know what's the square footage and what's the lot size? No such thing as official square footage. Do you know the assessor has an opinion, the appraiser has an opinion, the builder has an opinion, the seller has an opinion, the inspector has an opinion, the architect has an opinion, everybody has an opinion, and no one's opinion is right and no one's opinion is wrong. So the idea is, but the buyer says, no, really, tell me what the official square footage is. So we've always had on the statewide buyer and seller advisory form something that tells the buyer, you know, don't rely on the realtor for the square footage. It's just approximation. It hasn't been verified, so that's good. But this form goes a little bit further, because this form just deals with square footage and lot size. You give it to the buyer, you're telling them, listen, if you want to know what the real square footage is, hire your own person to measure if you want. But there's a chart on this form where you can write down what the assessor thinks, what the appraiser thinks, what the seller thinks, what the builder. In other words, you can actually give them in writing the various square footage opinions that people have, and it says right on the form they acknowledge that, you know, there's no one that's official. They can check for themselves. The realtor certainly didn't verify it themselves. It's all an approximation, blah, blah, blah. And as far as lot size, you know what the form says? The form says, if you want to know what the lot size is, there's only one way: hire a surveyor. Do a survey. If you want to know if the trees or the fence or the hedges are on the boundary line, the only way to know for sure is to get a survey. I, the realtor, am not guaranteeing what the lot size is, and I'm not guaranteeing that fence is actually on the boundary. So, see, the purpose of these forms are to protect the realtor. You don't have to use them. I'm sure it'll be your company's decision whether you're going to require that form or not. But those are the only two forms that are going to be coming out in June. Okay. Things you should know about, of course. Yes, you can DocuSign the PED form. Listing agent said she doesn't want to accept it DocuSign. That's their business. Client who lives out of state wants to sell their tenant occupied rental, waiting for her to verify if the tenants are month to month or a lease. Month to month, she can give a 60-day notice, but then you're going to run into the issue of them not leaving. If they don't, she won't have any recourse until August 1st when the courts resume. Yes, even though the eviction eviction is for selling the home. It doesn't matter what the reason is. The courts are closed for evictions until the 1st. One more thing I want to tell you is but I think you're aware by now that there's some relief programs that realtors are eligible for. One is called the PPP, the Payroll Protection Plan, where you may be able to apply for a short-term loan that's forgivable, which means you don't have to pay it back. That would basically replace 2 months of reduced or lost income if you have 2 months of lost income before July 1st based on this COVID-19. How do you apply for this? You go to your local lender. If you have any questions, we have a phone number, a hotline, 213-351-8450, 213-351-8450, where experts are standing by. Also, the second program is the PUA, Pandemic Unemployment Assistance. Remember, normally independent contractors are not eligible for unemployment insurance. Now you are. This pandemic unemployment assistance you are eligible for. You are eligible for up to 39 weeks of unemployment. How much are you going to get? Well, it's retroactive back to February 1st, even if you haven't applied yet. And you would get, if you're eligible, $167 per week, February and March, but then April, May, June, and July, you can get up to $600 more than that, like $767 a week, and maybe even more. Is it taxable? Yes. Federally, not state. But the point is that may be better than that forgivable loan. This may be the best option for you. Now, if you're still working, making commissions, that's going to affect your unemployment. It doesn't mean you're not going to get any of this. You still might get some, right? If you're not making any money at all, you maybe get the full unemployment benefit. We emailed out to every realtor a week or so ago an application that you can fill out online to get the PUA. If you didn't get it, or if you have questions on the application, that's why we got this phone number, 213-351-8450. And we also have a special website, car.org/coronavirus, which is linked to your regular website, car.org. We got FAQs up there. We got information talking about on the forums. We're going to update you as things change. And remember, what's going to happen this week is once we hear back from the government, either way, we're going to update the best practices that you've all been following all of these last 2 months, and it may have some changes on it. But as long as you're using the PEAD form, the PEAD form, and you do what that form says, you should be okay. So we'll keep you posted. And guys, I don't see any more questions. Phone number, Anna, 213-351-8450. Tell you what, I'll even type it in the chat. 213-351-8450. Relief hotline.
There are a few more questions in the
meantime,
Q&A if you have time, Gov. But
okay, sure. Are they? Oh, here we go. Do you have to remove shoes or wear booties? You know what the rules say? If it's reasonable and necessary. To me, reasonable means, do you actually have booties? Can you find booties? I think in a perfect world, you wear the booties, but I don't think anyone's too strict on that. Do you submit the CVA form with the RPA when presenting an offer? I would, if you like the idea of the form. I was approved for PPP and PUA. I don't want PUA and cannot reach anyone to cancel it. You don't want the free money? Okay, I don't know. Call that number. They will help you. Parveen, including the P, does the buyer also need to provide, what's POF?
The funds.
Proof of funds. Stanislaus says you should only be showing buyers who are either pre-qualified or proof of funds. I think that's what Stanislaus County's local rule says. Right, Jim? Is that what it says?
And the feedback I've been getting on that is most people aren't showing houses to people without proof of funds anyway. So that little tweak is not that big a deal.
Yeah. So that's a Stanislaus County thing. Titus Zamora, yes, call that phone number, please, to get help on the PUA and the PPP and all that stuff. Since the courts aren't open until August, how long do you think it will take the courts to process the evictions? Good point. Probably a whole nother month after that. Diana Stein, is it based on prior commissions? Depends on if you're referring to the PPP or the PUA. The PUA, and I'm not the expert, call that phone number, but I mean, yes, it's your prior income. It definitely affects the PPP. As far as I'm not sure how exactly they calculate how much of the unemployment you're going to get. That's why I'm not an expert. That's why they have experts. So call them, please.
Thank you very much, Gov.
My pleasure. In the meantime, do whatever Jim tells you to do.
Well, if you gave opposite advice, do what Gov does. As Gov's been doing this longer than I have. With regard to the CARES Act stuff, we've been referring people to your website, to the webinars and that sort of thing. And I know you're not an expert on that. I'm not either. But you guys do have people who are really up on it. But even those guys are not, there's not a lot of guidance with regard to that. So,
some of these things there aren't answers for. You're right.
Yeah, one of the questions I'm getting a lot is, can you apply for the PPP and the PUA? And it sounds like there's not a definitive response to that. So I would refer anyone who has those sorts of questions to go to covidupdates.com or .org, whatever it is. Call that phone number that Gov gave. And in the meantime, we look forward to seeing the updated best practices, because that's really what we're relying on at PMZ. And especially with regard to these little tweaks that have happened, the PED notice and that sort of thing, posting of that. But so we'll look forward to that. And in the meantime, thank you very much. We really appreciate it. Hopefully next year we'll be at the State Theater and have a bigger production and get to see you in person. So thank you very much, guys.
My pleasure. Thank you and goodbye.
I see you.